The honourable member for Portage-Lisgar.
Well, thank you, Mr. Speaker. I am honoured that my colleague from Kitchener Centre asked me to speak on her legislation, Bill C-240, the Offender Rehabilitation Act. Before I begin, too, I'd like to congratulate her hometown, Kitchener Rangers, on winning the Memorial Cup last night. Well done, lads. Now, her opening speech on this legislation is worth watching for anyone, but especially someone struggling with addiction right now. And I commend her for her courage in telling her own personal story of recovery. The fact that she is in this place is a testament to not just her as a person, but highlights what can be achieved in recovery. And Bill C-240, it starts with a common sense idea that I think all Canadians can rally behind. Prison should protect the public, and prison should hold offenders accountable. Prison should also require people do the work needed to change before they are released back into our communities. Canadians can see the problem quite plainly. The person who broke the law gets endless second chances, while the victim and the community are left paying the price. Repeat offenders cycle through the system, trauma not healed, addictions getting worse, and too many people leave prison no better prepared for life outside than the day they entered. That helps no one. Not the victim, not the community, and especially not the offender. A serious justice system tells the offender the truth. You cause harm. You are responsible, and now you must do the work to change. And to the victim, it has to say something just as clearly. What happened to you matters, and your safety should come before the offender's convenience. This legislation would give judges a new tool. When a judge sentences an offender, they would be able to order that offender to take rehabilitative measures during their time in jail. Now, that could be job training, it could mean apprenticeship or technical skills, it could mean education, and most importantly, it could mean treatment for drugs and alcohol addiction. Right now, too often, prison is treated like a waiting room. The offender serves their time and waits out the clock. Then they return to the same street, the same addiction, the same lack of skills, the same broken life, and the same risk to public safety. Too many Canadians are tired of this revolving door justice system. When someone is released from jail, they move into a neighborhood full of people who have every right to expect that our justice system has done more than simply count down the days on a calendar. This bill will help change that. It says that if a judge orders an offender to take training, education, or treatment, that order should not be just forgotten once the offender actually enters jail. The order should be sent to Correctional Services Canada. It should be reflected in the correctional plan. And when parole is being considered, the parole board should be able to look at whether or not there was progress made. The bill does not pretend that every offender will change. It does not punish someone because the program is full, unavailable, or delayed. But it does say if help is offered, if training is available, if there is a path to a better life, the offender has a responsibility to take it. If someone wants early release, Canadians are entitled to ask what they have done with the time that they were given. Did they learn a trade? Did they put in work to overcome their addiction? Did they show any sign that they are any safer today than when they entered prison? Release should be earned through progress and should not be automatic. It shouldn't be detached from behavior, effort, or rehabilitation. Now, Mr. Speaker, I come at this from a Manitoban perspective, and in my province, these problems are very real. Families in Portage and Winkler and Morden and Altona and Carman and communities right across our great province know what repeat crime looks like and what it does. They see the addiction, the stolen trucks, the break-ins, the violence, and the heartbreak that follows. In 2024, Manitoba's crime severity index was far above the national average. People don't need a chart telling them that something has gone badly wrong. They feel it when they check 2 or 3 times whether or not the garage is closed or the car is locked. They feel it when a business owner replaces a broken window yet again. They feel it when parents wonder whether their community is safe for their kids. And they especially feel it when police are arresting the same person over and over again. And now Manitobans are being told that the answer to addiction is a drug consumption site in Winnipeg. It is absolutely not. Let us be honest about what many families and businesses fear. They worry it will become another drug den, another place where government manages decline instead of enabling recovery. They worry that the neighborhood will be asked to carry the cost. Local concerns will be brushed aside by people who call themselves compassionate, while ignoring the fear of the grandmother, the shop owner, the student, the young family, and the police officer dealing with the fallout. They base this on what we have already seen take place across the country where this experiment has been tried. The answer to addiction is not to build a system around permanent dependency. The answer is recovery through treatment, because we know it can work. Treatment that helps someone suffering with addiction find purpose and meaning in life, to deal with trauma, to understand what they are trying to escape and why, to recognize through whatever modality works that they have a problem, that it can be solved, and that recovery is possible. The answer is a justice system that separates the addicted person who needs help from the fentanyl trafficker who profits from death and misery, and deal firmly with both problems. Bill C-240 does just that. It says people struggling with addiction should be directed towards treatment and rehabilitation. It also says those trafficking fentanyl on a large scale deserve tougher sentencing consequences. And that distinction is necessary. The person trapped in addiction needs a path out. The person selling poison on our streets needs consequences. That is why this bill is both tough and humane. It is tough because it refuses to accept a justice system that releases people without asking whether they have actually changed in any way. And it's humane because prison should not just hold people for a while and then send them back out broken, addicted, and dangerous. Many offenders enter custody without the basic education or skills needed to find and keep stable work. Many have never had the discipline, the support, the structure needed to build an honest life. Now, none of that excuses crime in any way, Mr. Speaker, but if we ignore those facts, we guarantee more crime. Someone who can't read well, can't hold a job, can't manage their addiction with coping skills, and has spent their sentence learning absolutely nothing about recovery is not safer nor rehabilitated because a date arrived on a calendar. They need to put in the work while incarcerated. The public deserves more than a release date. The public deserves evidence of effort. Now, some will say this is too hard on offenders. I say it is more cruel to leave people trapped in the same spiral that they are in and call it mercy. Nobody wants to be addicted to drugs or alcohol. Let's make sure they have a way out. Now, some will say we need more programs before judges can order participation. Then let's expand the programs. Let's fix prison education and make sure training matches real labor market needs. In Manitoba, we understand the trades, we understand work, we understand the dignity in showing up and earning your way. If somebody in custody can learn and go through addiction recovery, then that should not be treated as optional, an optional extra. It should be treated as the goal. It should be part of the sentence when the judge says it is needed. We should want people leaving custody with clear eyes, a plan, and a reason to not go back. To have hit rock bottom and started the work to claw their way up to a life filled with meaning, purpose, and service. The bill sends a message to offenders. Your time in custody must not be wasted. It sends a message to Correctional Services Canada that rehabilitation must be planned, tracked, and taken seriously. And it sends a message to parole boards. Progress matters. It sends a message to fentanyl traffickers. If you profit from addiction and death, you will face real consequences, as you should. Most importantly, it sends a message to victims and communities. Your safety matters. Your peace of mind matters. The justice system exists for the protection of the public, not for the convenience of the offender. We need a justice system that is serious enough to punish crime and honest enough to say that rehabilitation only matters when it is real. Now, some offenders absolutely can change, but they shouldn't be rewarded for saying the right things. They should be expected to do the very hard work that change requires. Bill C-240 is not the final word on earned release, public safety, or recovery, but it is a serious step in the right direction. It follows the offender from courtroom to custody to parole and asks a fair question at every stage. Are you doing the work necessary? The bill forces the justice system to take rehabilitation seriously. If we are going to release people back into our communities, then it is fair to ask what they have done with the time they were given on the inside. Canadians want a justice system that remembers the victim, protects the public, and both expects and enables more from the offender than simply waiting the calendar to run out. That is why I will be supporting this important piece of legislation. I urge every member of this House to do the same. Thank you, Mr. Speaker.